6 o'clock. Can we start the session, Mr. Yashodhar?
Please, sir.
Good evening. A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Yashodhar Hegde, Advocate High Court of Karnataka. Mr. Yashodhar, it's a pleasure to have you with us today. Welcome to the webinar.
Thank you, sir.
With immense pleasure, now I would like to introduce our today's speaker, Mr. Yashodhar Hegde, hails from Sagar Taluk of Shimoga district. He graduated from University Law College, Bengaluru. Since his enrollment, he is practicing with Pragati Law Chambers as a partner. He practices in a wide spectrum of civil and criminal laws, which includes white-collar crimes, property litigation, matters related to Hindu Religious and Charitable Endowments Act, education matters, claims litigation in connection with infrastructure projects, etc. He specializes in commercial litigation, white-collar crimes, and infrastructure and arbitration. He regularly appears before all trial courts at Bangalore, High Court of Karnataka, Debt Recovery Tribunal, NCLT. He also appears before National Green Tribunal and Enforcement Directorate and also Honorable Supreme Court of India. He is a trained tabla player and loves playing it during his free time. He is married to Srimati Spandana, who is also a practicing advocate. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you.
Sir, thank you so much. I would like to thank the Advocate Association Bengaluru for providing me with this opportunity. I am in fact very grateful. Thank you. So the topic that I have chosen for today's webinar is on dishonor of checks with respect to the Negotiable Instruments Act of 1881. My endeavor would be to focus on Chapter 17 of the Negotiable Instruments Act, which is from section 138 to sections 148. So negotiable instruments, as we know, are generally used negotiable instruments are promissory notes, bill of exchanges, and checks. When the Negotiable Instrument Act of 1881 was enacted, the legislature had only provided for a civil remedy in the event of a dishonor of a negotiable instrument. Civil remedies, when I say, I mean recovery suits. In the event of a dishonor of any negotiable instrument, the remedy provided was to institute a civil suit and litigate it out. However, with the opening up of the financial market in India, with the entry of MNCs and huge corporations, the usage of check became predominant. With the opening of the financial market, the EMI culture as well as the credit card became dominant. And the payment for these were started to happen regularly through means of checks. With the prominence in the use of checks, the dishonor of checks also started to increase. Since the only remedy available to a person whose check is dishonored was a civil remedy, and instituting a suit for recovery and in fact getting a decree would take a minimum of 3 to 4 years, the legislature in the year 1988 deemed it fit to criminalize the offense of check bounce. What before was a simple legal civil remedy for recovery, in the year 1988 became a criminal action. By virtue of the amendment of 1988, an offense of dishonor of check was made a criminal action, which was punishable with an imprisonment of 2 years and a fine which would be double the amount of the check amount which is dishonored. Now, after 1998's amendment, Chapter 17 was inserted to Negotiable Instruments Act, and sections 138 to 148 as it stands today were inserted. Now, sir, I would like to proceed to what constitutes an offense of a dishonor of a check. But before that, I would like to examine what is a check under the Negotiable Instruments Act. Now, section 6 of the Negotiable Instruments Act speaks about a check. And what it says is a check is a specified bill of exchange drawn specifically on a banker. Now, what is a bill of exchange under the Act? A bill of exchange is an instrument with an unconditional order to the person on which it is drawn, stating that when a person who holds the check or whose name it has comes to you, pay him an amount of money specified in that instrument. So, in case of a currency note, how it works is if I give a 100 rupee note to a person, I am transferring 100 rupee worth of value to him directly. In case of a bill of exchange, I am giving an instrument which is in tandem to a currency note, but it will say that I am ordering you to pay X amount of money to this person who comes to you. For example, if I have written a bill of exchange of 100 rupees to a person, it means that when a person who holds that bill of exchange goes to the person on whom I have drawn the instrument, he has to give 100 rupees to that person. Now, to simplify this with respect to a check is nothing but a bill of exchange drawn on a banker. That is to say, I have drawn a check on my banker telling him that when a person whose name which is written on the check or a person who holds the check comes to you, give him the amount of money which is mentioned in the check. That is a check under the Negotiable Instruments Act. Now, as I was speaking, with the use of check, with the dominance in the use of the check, the dishonor of check also started to increase, and dishonor of check was criminalized. Now, let us examine what constitutes an offense of dishonor of check under Section 138 of the Negotiable Instruments Act. Now, I would not read out the entire Section 138, but I would like to explain that Section 138 is a composite law, which means that there are ingredients that will have to be fulfilled for an act to become an offense of dishonor of check. Now, Section 138 of the Negotiable Instruments Act has 6 ingredients which are required to be fulfilled. Now, the first requirement, even as per the text of the act, is that the check is drawn by a person on an account maintained by him. I would go one by one with all the 6 ingredients. The first ingredient is that a check is drawn by a person on an account maintained by him. Now, this assumes importance because for an offense under Section 138 to be made out, the requirement is that the check, which is the subject matter of the offense, is drawn by the person on an account maintained by him. If the account is not maintained by him and the check is given and it is bounced, then one cannot sue for dishonor of check. To give an example, if I am the power of attorney holder of a person, say X, X has authorized me also to sign on his behalf on his check leaf. I have issued a check on behalf of X to A for a liability, and the check is it is presented for encashment and it is dishonored, and a case is filed. I am only a power of attorney holder of the person on whom the liability exists or who maintains the account. In such a scenario, I as an individual, as a power of attorney holder, will not be held liable for the offense of Section 138. The liability will only fall on the person whose attorney I hold. To give an example, if I'm holding Trivikram Sir's power of attorney and I have returned a check, then I will not be held liable personally. So this is the first requirement. And in fact, the Supreme Court in the case of Jugesh Sehgal has also fortified this to state that if the check is drawn on an account maintained by a third party, the person who has drawn the check cannot be held liable. Now, the second ingredient for an dishonor for an offense to be held to be maintainable under Section 138 is that the check has to be drawn towards the discharge of a liability. Now, there is a presumption under the Act which I will come to a little while later. However, the second ingredient as per Section 138 of the Act is that such a check should have been drawn towards the discharge of a liability. Now, if I consider a scenario where the liability is of a third party, now if I have issued a check in favor of somebody, but the liability is not mine, in a transaction, let's say, between me and Mr. Manu, I have issued a check to Mr. Manu. However, the transaction was between Mr. Manu and Mr. Trivikram. Now, in such a transaction, there is no nexus between me and Mr. Trivikram because transaction iddidu Manu ಮತ್ತು Trivikram ಅವರ ಮಧ್ಯ. I have issued a check for the liability that was of Mr. Manu's. Now, if that is a scenario, then the liability is not mine. So the check should have to be drawn towards the discharge of a liability of the person who has drawn the check. ಬೇರೆ ಯಾರ್ದೋ ಲಯಬಿಲಿಟಿಗೆ ನಾನು ಚೆಕ್ ಅನ್ನು ಡ್ರಾ ಮಾಡಿ ಕೊಟ್ರೆ I will not be held liable for an offense under Section 138. In fact, there is a very celebrated judgment of Supreme Court on this, that is the PJ Agrotech of a 2010 judgment. So the second ingredient is that that particular check will have to be drawn towards the discharge of a liability. Now, once these two ingredients are fulfilled, we go to the third ingredient where the check will have to be presented within its validity period. Even though the text of Section 138 says that the check has to be presented within 6 months or within its validity period, Now the RBI has also issued a circular where the validity of the check is restricted to 3 months. So regardless, even though the act says 6 months, however, as it stands today, a check is valid for 3 months from the date of inscription on the check. If I have drawn a check of 18th of September 2020, then from this date the check is valid for 3 months. So one of the ingredients of 138 is that the check will have to be presented before the banker within that period of 3 months. 3 ತಿಂಗಳು ಕಳೆದು ಹೋದ್ರೆ, that is what in general parlance we call as a stale check. On a check that has become stale, I cannot maintain a complaint under section 138 for an offense of dishonor of check. Now that becomes the third ingredient. The fourth ingredient is that once I present that check for encashment before my banker, that check will have to be returned unpaid. Now, once I give the check to the bank saying that this is the money that is supposed to come to me, if the banker returns a check, say not paying the money, then that is one of the ingredients that will have to be fulfilled. Now, if a general bank endorsement, when I say it has to be returned, I mean that the bank will endorse saying that the check is not paid, and there will be reasons mentioned. It may be funds insufficient, it may be signature not matched, it may be stop payment, it may be exceeding the mandate. Now, the different banks have different practices. There are various number of endorsements that the bank will give as to why the check is not honored. Each of these endorsements stand on their own footing, and there is no straitjacket formula to say that this endorsement will result in an offense of the 138 prima facie being made out. All of this will have to be looked into on a case-by-case basis. Now, once this fourth ingredient of the check being returned unpaid is satisfied, we will have to move on to the fifth ingredient, which is the issuance of a demand notice. Now, section 138 under the proviso states that once a person is aware of the fact that the check has been dishonored, a demand notice is to be made within 30 days. So 30 days from the date on which I know that my check has been dishonored, I will have to issue a notice under section 138 making a demand for the exact amount of the check which is bounced. Now, I would like to explain few aspects here because section 138 does not provide for any ambit for a magistrate court to condone the delay in issuing the notice. 138 is very clear that within 30 days of issuance of such a notice, of the receipt of the endorsement, a notice of demand has to be made. And in the event a person has made the demand notice, say on the 31st day, and a criminal complaint is instituted on the basis of such a demand notice, that complaint will fail and it cannot result in an order of conviction. In fact, in Sivkumar's case of 2009, the Supreme Court has held that no court has the power to condone the delay in issuing the legal notice. 30 days is a very strict timeline. 30 dina kalad hodre, I have missed the bus. I cannot then say that they, for whatever reason, even if the reasons are genuine, I cannot ask the court to condone that delay. Now the question arises is, if the party has come to me on the 29th day, the client did not know, he has come to me on the 29th day and he has told me, sir, a check bounce notice kadisi, and say the next day is a Sunday. Now there is a workaround to this as well. In fact, the law recognizes that as long as the check is valid, that it is within the 3 months validity period, I can present the check any number of times. It can be bounced any number of times, so to say, and I can also issue any number of notices with respect to such bouncing of checks. To give an example, if I have a check which is valid until November of this year, I can present it 5 times until November. And I can issue 5 separate notices for all the times the check have bounced. However, there is a precondition. If I am filing a complaint on the basis of these notices, then such complaint will have to be on the last check, that is the last instance of bouncing of the check and the last notice issued. Andre, if I have issued 5 separate notices, the moment I've issued the 5th notice, the previous 4 notice becomes invalid in law. I can only file a criminal complaint for dishonor of check on the last notice that I have issued. If I have sent a notice, say today, as well as the coming Monday, and I've issued a check on today's notice, I've instituted a criminal complaint notice that I've issued today. then the complaint will be bad in law and it is not a defect that can be cured. So as a complainant's counsel, it is always, the care has to be taken that in case there are multiple presentations and there are multiple notices issued, the last of the notice will have to be what forms the basis of the complaint. This is a ruling of the Supreme Court as well in MSR Letters of 2010. Now, once the notice is issued, we will now go over to the next aspect. That is the sixth and the final requirement. Before I go, excuse me, there is one other very crucial aspect for person who issues the notice for dishonor of check. That is, when a notice is being issued, care has to be taken to specifically mention the amount of which the check was drawn for and the particulars of the check. When I say particulars, I mean the date of the check, the number of the check, the bank on which it was drawn. The reason is this, because criminal law has to be construed strictly. In a notice that I sent, if I have made any discrepancy or a mistake when compared to the check, ಈಗ ಚೆಕ್ ನಂಬರ್ 30 ಅಂತಿದ್ದು ನಾನು ನೋಟಿಸ್ ಕಳಿಸಬೇಕಾದ್ರೆ 40 ಅಂತ ಬರೆದಿದ್ರೆ, if I have instituted a complaint on that notice becomes bad in law and the complaint will fall because of the discrepancy in the notice. This in fact is also another Supreme Court judgment in in Suman Sethi of 2000. Now what happens is, if sometimes clients come to us in a composite transaction, they will say, sir, check amount istide, interest ist barbeku. There was also another agreement through which another sum of amount has to come. Say the check amount is 10 lakhs and the client says, sir, 3 ವರ್ಷದಿಂದ ನಾನು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ, ಅವರು 10 ಲಕ್ಷಕ್ಕೆ ಒಂದು 5 ಲಕ್ಷ ಇಂಟ್ರೆಸ್ಟ್ ಆಗುತ್ತೆ, and there is some other money that he owes me. If that is the case, then one cannot issue a legal notice for dishonor of demand notice for dishonor of check accumulating all these amounts, because that would result in a discrepancy in the notice. The ideal course of action would be to issue a separate notice with respect to the check which is dishonored, and maybe a separate notice with respect to the rest of the money that is owed by the person. So this is one aspect which will have to be cautiously treaded, to say that the particulars of the check will have to be mentioned very specifically and clearly. Now, once a demand notice is made, the next step would be for making of the payment. So within 15 days from the receipt of the demand notice, the accused, the person who is named in the notice, will have to make the payment. Now, the reason why this becomes important is the mere bouncing of the check, mere dishonor of the check, does not constitute an offense under Section 138. Section 138, as I mentioned earlier, is a culmination of 6 ingredients. What constitutes an offense is bouncing of the check and inability to and failure to pay. So there is a distinction when I say failure to pay, because there's a distinction between a failure in payment and inability to pay. In a scenario where there is an inability operating because of a statute or because of an extraneous consideration, say my bank account is seized by the enforcement directorate for whatever reason. I have issued a check, there are sufficient amount in my check, I had every intention to honor the check. However, because of operation of a statute or law or an enforcement agency, my check is not cleared. Then that is not considered as a failure to pay. It is in fact an inability to pay. I will dwell on this a little further when we come to rebutting the presumption. However, if there is an inability to pay, a person can always demonstrate that it is not a failure and an inability, and that will always come to the rescue of an accused in these proceedings. Now, the other question that also comes at the time of issuance of the notice is, if it's a company, if the check is issued by a company, who and all will have to be named as the recipients in the notice. If it's a trust or if it's an association of persons, I will deal with this when I come to Section 141. However, the other aspect that will also have to be taken care of with respect to the receipt of the notice and non-payment within 15 days is the timelines, which I will also again deal with when I come to Section 142. Now, once, as I was speaking, Section 138 is a culmination of all these 6 offenses. Once all these 6 ingredients have met, the next course of action available to a person is to institute a private complaint under Section 200. Now, because the law, the Negotiable Instruments Act of 1881 is very clear that Section 142 states that by no other way but by a private complaint can an offense of 138 be prosecuted. Therefore, after the ingredients under Section 138 are all met and fulfilled, The next course of action would be to institute a private complaint for dishonor of check. Now, the question that now will arise is, when do I file the private complaint? Is there a limitation? Yes. So section 142 states that within 30 days from the date when the cause of action under 138C arises. 138C of the Negotiable Instrument Act is the last ingredient that we spoke about, that 15 days from the date of the receipt of the demand notice. So the reason why the law has given this time is, imagine a scenario where a person who was genuinely interested to pay the check could not make payment for whatever reason. Now the person whose check has bounced has to be given some benefit of the doubt to say that, okay, fine, that is why the legislature has kept that in mind and said, in the event of a dishonor, a 15-day period will have to be given to the accused or the person whose check has been dishonored for him to make the payment and remedy that wrong. Therefore, if an argument is taken that the law is draconian and it is only complainant friendly, that may not be true, because in the case of genuine transactions, 15-day buffer period is given to the person whose check is bounced for him to make the payment. Now, coming back to section 142, 142 states that a person has 30 days from the end of the 15th day from which the person had to pay. For example, if the non-Kutara check bounce agide antandre, I have 15 days from the day I received the notice to make the payment. Considering I don't pay, from the 15th day, I have 30 more days to file the criminal complaint. So the formula that we usually use in practice is 30, 15, 30. That is 30 days after the bank has given me the endorsement that the check is dishonored, 15 days from the date of the receipt of the notice for the noticee to pay the money, and 30 days thereafter for me to institute a complaint. Now, these are the timelines under the Act. However, a question will also arise that how do I calculate the period of 15 days? If I have 15 days plus 30 days, na 45 dina from the date of institution receipt of the notice do I calculate? Andre notice kadastagina 45 dina calculate madla, or should I calculate 30 days exclusively from the date when he receives the notice? Or how do I do it? Now, though the Act does not mention that the notice will have to be sent through registered post, it only says a demand has to be made. It can be a handwritten notice, I can deliver it by hand, I can send an RPAD, I can send a speed post. However, as a matter of prudence, because proving that the fact that a person has received the demand notice is an issue, it is always advisable to send a registered post with acknowledgement due or a speed post acknowledgement due. The reason is this: if I issue an under certificate of posting, then it is only a proof of the fact that I've issued the notice. If I send a courier, I can only demonstrate that I have sent the notice. Whether the noticee has received the notice will again become a question. So the safest bet is for a person to issue a registered post with acknowledgement due. Now, then again, there are multiple questions. What if the person rejects the notice? What if the person does not claim it? What if the addressee has left the premises? These are practical difficulties we face every day in these matters. In the event the person refuses the notice and say the endorsement by the postal department says refused. Now the law is very clear that refusal is deemed service. So from the date of refusal, 15 days will have to be calculated. End of 15 days, I have another 30 days to issue the notice. Now say in the case where it says the addressee is left and with best efforts, a person cannot find out what is the new address of the particular person. If I have issued the notice, I do not know where the noticee now lives. Endorsement says addressee left. Now even then, what the courts have held that by taking refuge under section 114 of the Evidence Act and section 27 of the General Process Act, once I have issued the notice to the last known address of the noticee, the person who I'm sending the notice to, I have done my job. When I send the notice from my end to the last known address, it is deemed that the notice is issued from my end. I have complied with the requirement of section 130. However, the law has not lost the sight of what the accused would want to do in these circumstances. When the accused comes on record, after I institute a complaint, they come on record, the accused can always prove that the notice was never served on him, he had never received the notice. In fact, The ground that the notice was never served on me is a very good defense available to an accused counsel before in the course of the trial of a section 138 matter. Now consider a scenario where it says the notice is unclaimed. People try to avoid notices. They will say that they are not in station, or they will say that this is not that particular person's house. So then the postal department will write something called as unclaimed endorsement and send it back to the sender. Now, in case of unclaimed endorsements or addressee left, there are two views that the courts have taken. One view says that a person will have to wait 30 days from the date of issuance of the notice. If the AD card never comes back, then you wait 30 days. And from 30th day, you have 30 more days to file the complaint. That is number one. In cases where the notice is unclaimed, or it says that the address is not found or any of those, then the courts have held that a reasonable prudent man, that is the prudent man would, the prudent time that would take for the notice to be served is 15 days, or that 15 day will have to be calculated from the date when the notice was unclaimed. So there are two options to a person. If AD card barale, if the acknowledgement has never come back at all, then the best way to do it is within 45 days from the date that I have issued notice, file the complaint regardless. If I have received the notice, obviously I will calculate the 15 days from that date. If it is unclaimed, or if it says the addressee is left, if I get an endorsement like that, from the date the endorsement is written, we have to calculate 15 days from that date and then 30 days for filing the complaint. Now, the law has given the power to the respective magistrates to condone the delay in filing of the complaint under section 200. When we spoke about issuance of the demand notice, we have examined that there is no power for any court to condone the delay in issuing the demand notice. However, after the demand notice is issued, served, for me to file the complaint, I have 30 days, criminal complaint. For me, in filing the private complaint, if I have had any difficulty and I was not able to file it within 30 days, then I can always seek refuge under section 142 subclause B, and I can seek the court to condone the delay. This, the court has ample powers, provided I show sufficient cause. I cannot go to court simpliciter say illa nan madakagilla 30 dina 31 dina hakidini anta. Simpliciter, if I say I want the delay to be condoned, then the court may not appreciate it. Sufficient cause will have to be shown to show why was I not able to file the complaint within 30 days. Now, this is where what we usually advise the clients to do is the moment the check is dishonored, immediately the notice is sent so that that time is not lost. And immediately after the RPAD card comes back, immediately the complaint is also filed so that limitation does not become a problem. Now, the other question that arises after the notice is served is, where do I file the complaint? Now, in a city like Bangalore, we have various numbers of small causes court halls as well as magistrate courts which have a jurisdiction for dishonor of check. Now, if I have issued a check from an account that I maintain in MG Road, and the person who has received the check deposits it, say, in Girinagar. Now, do I file it at 42nd ACMM or 10th ACMM or at 13th ACMM? What is the jurisdictional magistrate becomes a question. Now, the Unamended Act of 1988, the Negotiable Instrument Act, did not mention what the jurisdiction for filing the check bounce was. Thereafter, there was the case of Bharat Steels, and then which was then considered in Dasharath Roop Singh's Rathod's case in 2018, where the court held that the jurisdiction would be where the drawer of where the person deposits the check. Now, what happened as a result of that is Nanu Bengaluru Kotiro check kanna, somebody would take it to Jammu and present it in Jammu, get it dishonored there, and a case is instituted there. So for me to defend myself, I would have had to travel from Bangalore all the way to Jammu. The legislature saw this as a problem, and therefore the 2018 amendment was inserted to section 142, where the jurisdiction has been made very clear. There is no ambiguity now. Where the drawee of the check presents the check for encashment, that is where the offense is made out, and the jurisdictional magistrate who exercises jurisdiction over that area will be the jurisdictional magistrate before which the complaint will have to be filed. That is to say, if I have issued a check from my account in NG Road and the check was presented by the person in Hanuman Nagar or in Girinagar branch, then the check will have to be filed before the magistrate who has jurisdiction over Girinagar police station. Now there is no more ambiguity with respect to this aspect. The law stands, the amendment makes it very clear. Now, once a check bounce case is instituted, the question arises is how will the prosecution begin? Section 143 of the Act specifically states that it is a summary trial and it is a summons case. What does the law, what does the legislature mean when they say it is a summary case and a summons trial? What they mean is once the complainant has filed the private complaint and once he has adduced his evidence, Section 145 of the Negotiable Instrument Act gives me the power to adduce evidence right after I file the private complaint. Once I have done that, if the court has found prima facie case, then the court can issue summons directly to the accused. The accused can come on record, his plea will be recorded, his statement under 313 can be recorded. Thereafter, the trial would begin and the judgment would be pronounced. So, the entire rigmarole of charge and the allied procedures that otherwise would have to follow under CRPC is not applicable to a trial under Section 138. It is a summons trial and it is a summary trial. Now, we will now go over to Section 141 of the Negotiable Instruments Act. As I was speaking about the issuance of the notice, one question that arose was, company check kotre, nan yaar mele case hakli, yaar mele notice kadasli. It becomes a very important question. Now, if say a company has issued a check and I do not know who has signed, somebody from the company has signed, it only says for Yashodhar Hegde Company Private Limited. Who do I file the case against? In the case of a company, the answer is very simple. Every private company has to be registered under the ROC. So if one person goes to the Ministry of Corporate Affairs website and puts in the company's name there, the entire biodata of the company is available. So the names of the directors, the registered office of the company, everything is readily available there. So in case of a company, Section 144 states that if a check is issued by a company, then the persons who are in charge of the company are also liable for an offense under Section 138. Now this becomes important because the law gives this impression that the directors of the company are supposed to be the mind of the company and they are the ones who run the company. So the general practice is in case of the company that has issued the check, the signatory of the check automatically becomes liable by virtue of Section 138 read with 141. However, the directors of the company can also be held liable for 138. However, there is also a catch here. There is a rider that the law provides. There are two riders that the law provides in this, that number one, I will have to, in the private complaint that I file, I will have to make specific averment stating that the persons that I have named as accused were in fact in charge of the affairs of the company. They were responsible for the conduct of the business of the company and the transaction which culminated in the check being issued. They were a part of it. Eno sambandha illaro director na, I cannot make them a party. This in fact was held in SMS Pharmaceuticals versus Neeta Balla's case of 2005, where the Supreme Court held that if the directors of the company are being arrayed as accused, then it is necessary that the private complaint specifically mentions that these individual directors, these directors were in fact in charge of the affairs of the company and they were responsible for the conduct of the business of the company. In the absence of such averment, if I have plainly said these are the directors are liable, the Supreme Court in the case of Anita Hada of 2012 has said that a bald assertion or a simpliciter assertion that they were directors of the company will not be enough. Having said this, if I'm for the counsel if I'm for the accused, the question I have is not, I had nothing to do with this transaction. In Yashodhar Hegde Private Limited Company, I am one of the independent directors. I had nothing to do, but I am also made an accused in that complaint. So what do I do? The question would arise. So the court has also looked into this aspect. In fact, in the same judgment of Anita Hada, the courts have said that as an accused, as a director, I always can prove that I had one, no knowledge of this entire transaction. Second, I was never involved in the affairs of the company. So if as an accused, I am able to prove these 2 points, that one, I never had anything to do with this entire transaction and I was never involved in the affairs of the company, which resulted in the issuance of this check, then I will be absolved of liability. I cannot be convicted on that ground. So 141 in fact is balanced both towards the complainant, that is the person who the check has been issued to, as well as the person who is facing the prosecution because of such a check. Now, there is one other aspect to the check which is issued by a company is section 149 of the Companies Act. If I'm an independent director or if I'm a nominated director, then again, by virtue of the operation of law, I will need to be excluded from the liability under section 138. So independent directors usually are people where investments are made and they're only there to regulate their investment to see how the company is working. Now, if I'm such a director and the company has issued a check for whatever transaction, then I cannot be held automatically liable. That would make dealing business extremely difficult, and it would defer the commerce interest of the company. That is why, by virtue of 149, if I'm an independent director or nominee director, then I cannot be held liable. However, as a complainant, if I'm able to show that the independent director was in fact involved in the entire transaction, which resulted in the dishonor of the check, I can always thereafter bring them on record under section 319 of the CRPC. That is summoning the additional accused. There is a judgment of Supreme Court of 2014 which says that even in a 138 proceedings, if it is established that an additional person was in charge of the affairs of the company, he can also be arraigned as an accused at any later point of the trial. Now, this is in case of a company, it's clear cut that the information is available out there. Now, take the scenario of the case when it is a trust. I only know who the trustees are. I do not know who the other members of the trust are. Or in case of a society, where I only know who the key members like the president or the secretary are. In these cases, there is no shortcut way of knowing who the people responsible for the act are. So the safer thing to do in these cases are to name the entity which is issued the check, and the entity and the persons who are responsible, who were instrumental in the issuance of the check. They will have to be named, and during the course of the trial, if any new evidence comes to light which says that some other person were also involved in this entire transaction, they can also be added as additional accused. In case of a proprietary concern, it is only one person, a single man show. The proprietor will be liable, and he will have to be the person who will be prosecuted. In case of a limited liability partnership, however, there is a slight gray area in the statute itself, because the Limited Liability Partnership Act gives a protection to the partner with respect to the liability, saying it is limited. In case of a fraudulent transaction, though the law says that the director is liable unconditionally, in these cases, then again, it becomes the burden on the complainant to prove that say one partner has issued the check, the LLP has 3 partners. If I've named all 3 partners, if I'm the complainant, I will have to prove that all 3 partners were involved in the affairs of the company. And I have an additional burden in case of an LLP. That is one thing that one has to keep in mind if the transaction pertains to a limited liability partnership. Now, the other question now there is, okay, if I have a check and it is bounced and I filed a complaint, as an accused, what do? Do I not have any scope to get out of the liability? That is where section 139 of the Negotiable Instrument Act comes into place, where there is a presumption, and it is a rebuttable presumption. I will first go over what the presumption states. Now, if section 139 by itself is considered, 139 states that there is a presumption that the check was received towards the discharge of a liability. If it's looked at independently, it may not make too much of a sense. However, if 139 is read with section 118 of the NI Act, 118 of the NI Act states that a check is presumed to be issued for a consideration. 139 states that the presumption is that such a check is issued towards a discharge of a liability. Now, to put it colloquially, how it works is, as a complainant, as an accused in a 138 transaction, I am the opening batsman with my eyes blindfolded facing a Yorker. Because the moment I enter appearance, there is a presumption that no, you have issued the check for consideration, and the check was issued towards a liability that the complainant is seeing. So when I enter appearance, there is a sword hanging on my head which states that you are prima facie presumed to be liable for this transaction. Now, this is what the presumption under 139 says. However, the law as it stands today has been evolved from time to time, where the Supreme Court has time and again held that this presumption is rebuttable. In Hiten P. Dalal's case of 2001, the courts have held that the presumption under 139 is not absolute. Just because there's a presumption doesn't mean the moment I enter appearance, I should be convicted. No. The presumption is rebuttable. When they say rebuttal, they mean that I can always show the court that the presumption is not true in this case, or it need not be the only truth in this case. So the courts have time and again held that the rebuttable presumption under 139 is by preponderance of probabilities. That is, to simplify that further, what preponderance of probability means is I will, as an accused, I only have to show the court that there is another probable version of what the complainant is saying. If the complainant is saying, for example, if the complainant is saying, "Illa adondu kage ide, aa kage belligide," that is the case of the complainant. As an accused, I only have to give probabilities to the court to say, no, that need not be a white crow. That can be a brown crow, or it can be a pigeon altogether. It can be a parivoda also. If I'm able to show to the court that there is one more possibility of the version of what the complainant is saying, I have discharged my burden of proof. To say that there is, once I enter as an accused, there is a burden of proof on me to rebut the presumption. Once I have rebutted the presumption, now the mountain for the complainant to climb is much higher, because the courts have held that once an accused is able to rebut the presumption under 139, the burden of proof for a complainant is to prove his case beyond all reasonable doubts. So as a complainant counsel, if the accused has come on record and he is able to show that this transaction itself is not a valid one, then as a complainant counsel, I have a very difficult task to prove that there was a transaction. For that transaction, a check was issued. In fact, the check was issued to the money that I owed in relation to that transaction. So it becomes much harder for a complainant to prove. Now, rebuttal of a presumption is a very wide aspect, and it is a very case-to-case aspect to say that it depends on the complainant and the case of the complainant to see what presumptions arise and how can that be rebutted. However, there are a couple of rebuttals that are used widely and are used regularly also in the courts of law. I would like to go over a few of them. Now, before that, I would also like to say that there are two kinds of defenses that I can take. I'm speaking from an accused perspective now, because we are on the presumption and the rebuttal there too. Two defenses that I can take, one are technical defenses, the other are the legal defenses. Technical defenses are the one where there is a delay in issuing the notice, or the kinds where the notice is discrepant with respect to the check amount, check number. So there is a discrepancy in the check. Now these are the technical defenses available to me. Coming back to the legal defenses, these are the ones that fall under the category of section 139. When I'm rebutting the presumption, I raise certain defenses. They are strictly legal. So the endeavor in rebutting the presumption under 139 is to tell the court that one, the transaction itself was not legal, or the debt which is being to be discharged, which is claimed to be discharged by way of the check, was not legal. Now, for example, if a person has filed a complaint stating that there was a loan transaction, hand loan, and during the course of the trial, it is established that the loan was exceeding 20,000 rupees, then one can take the defense of section 269 SS of the Income Tax Act, which prescribes that if a hand loan is issued which is worth more than 20,000, it has to be done only by way of an account payee check. Section 271 of the Income Tax says that if such a loan transaction is in fact done by cash, then there is a penalty levied and per se it becomes illegal. So if a statute prohibits the hand loan which is worth more than 20,000 by way of cash, and if the complainant has in fact said that it is a hand loan which was worth 1 lakh, then I have established that the loan itself may not have been legal. I don't need to establish that it was not legal. I only have to tell the court that look at the possibility that the loan itself was not legal. How can the recovery of the loan can be done through the court's process? Now, when I speak about rebuttal of the evidence, I don't necessarily mean that the accused will have to come to the box to rebut the presumption. Now, there are two issues also available here. One is under section 313 of the CRPC. Section 313 CRPC empowers the magistrate to directly question the accused and explain to him all the incriminating evidence against him. To put it simply, it is a dialogue between the magistrate and the accused, where the magistrate asks, see, this is the allegation made against you. These are the documents that the complaint is relying on. What do you have to say? Now 313 subclause 5 gives me as an accused the power to produce documents, a written statement along with the documents to the court. This written statement is not made on oath. I do not have to bind myself to what I say there. And I am also permitted to put out my version of the facts. Now, under the criminal law as well as the constitution, I as an accused have a right against self-incrimination. I cannot be forced to shoot myself in the leg to say that illa nan kotte check kotte bounce agbiduttanu. As an accused, I can always remain silent. That is the reason behind the concept of the accused not needing to lead evidence by himself. An accused can always take refuge of the documents and the complainant's version of facts through his oral or documentary evidence, and that can be used to rebut the presumption. This again is fortified in the celebrated judgment of Krishna Janardhan Bhatt, which was again upheld in Yashodhar Hegde's case later. However, one of the avenues available for me to rebut the presumption is by poking the hole in the story of the complainant by oral and documentary evidence. The other way I can do is, as I was speaking earlier, in section 313. In a 313 statement, I can always file a supplementary written statement with 313 subclause 5. I can enclose the documents that will sufficiently rebut the presumption under section 139, and that way I would have discharged my burden, and then it is for the complainant to prove his case. Now, one of the other defenses that is also available is the capacity to pay. If the complainant who is issued the check does not have the capacity to pay that amount of money, and if such an amount of money is not depicted in a person's income tax returns, say for example, I am a 20-year-old graduate who started working 1 year ago. My yearly salary is 10 lakhs, but I have issued a check of 20 crore, and the check has bounced. Now, where do I get 20 crores becomes a question. So the capacity to pay that amount of money will have to be established by the complainant himself, because once I as an accused rebut the presumption and show the court that one, IT returns have not been filed, or in the IT returns that he is showing, that amount of capacity is not forthcoming. That is what, if I'm able to show the court, then I have rebutted the presumption again. One of the other defenses that is usually raised in these proceedings when one is for an accused is that under the Money Lenders Act. Now, the Karnataka Money Lenders Act has a specific provision which states that if a person is in the business of lending money, and if a person is not holding a valid money lender's license, then he is not entitled to get a decree. Now, the word used in the statute is decree. However, a defense can also be raised to state if the transaction is a money lending transaction where multiple transactions have taken place, interest is levied and the interest is paid, then what happens is I have in fact lent money for profit. By definition, I become a money lender, and if I don't have a money lender's license, by virtue of the act of lending becomes illegal because it is in contravention of the Money Lenders Act. So when I give that money, I've given it illegally. So for a recovery of a money which was lent illegally, if a check is given and that check is sought to be enforced towards discharge of a legally enforceable debt, because section 138 states that the check should have been bounced towards a legally enforceable debt. Now, a debt which is illegal cannot be enforced illegally or legally for that matter. So if the accused is able to give a possibility that the debt itself was illegal, then the recovery of such a debt by way of a check cannot be held to be legal, and the proceedings under 138 may not be maintainable under those circumstances. Though there is a slight gray area in this aspect as well, because our High Court has held that section 138 and Money Lenders Act may not have a nexus, and for a prosecution under 138, the bar under the Money Lenders Act need not be applicable to that extent. However, the Bombay High Court as well as the Andhra Pradesh High Courts have conclusively held that if the money is lent by a money lender without a license, then the check issued towards the repayment will not constitute an offence under 138 of the Negotiable Instrument Act. Now, the other defense available is security checks. Now, with respect to security checks, again, there are two aspects. If a check is issued as a security towards payment in future, then such checks are under the ambit of 138. Now, if in a transaction, if I have issued a check to you stating that in 2 months' time you give me this, you give me a good, and at that point in time you can encash this check. and after I have given the goods and the check has been encashed, then I cannot take refuge under the security check and say that no, security there na, you could never have encashed it, so an offense is not made out. That is not available. In fact, in the case of Indus Airways, the courts has very clearly said that even if a security check is issued for payment of a money in present or future, then such checks they come under the ambit of section 138. However, if the check is issued only as a security and not for encashment, for example, say there is a lease agreement where I have issued a check for security deposit. Now, interest-free security deposit is something that has to come back to me. When I enter into the lease agreement, I am only required to pay the lease amount at the end of that month. And the person deposits the security check that I have given, and that bounces. Then, as on the date the check is dishonored, there is no liability on my part. Now, I do not owe any money to the landlord. So, if that security check is dishonored, then that does not constitute an offense under section 138. This is the same scenario if there is a transaction where I have promised you that I will give you 200 mobiles, and you have given me a check for the supply of those 200 mobiles. I supply 200 mobiles and the check is presented and is dishonored. However, before the check is presented, I have said that the goods are defective. When that is the case, if the goods are proved to be defective, then the check was only to be presented when the goods were completely delivered. And the goods delivered, the check should have been presented. So in case of defective goods, the security check will not be considered to be the one that was supposed to be encashed. So in those cases also, an offense under section 138 cannot be held to be maintainable. That will be that the court have held in Sampede Satyanarayana Rao. I'm sorry, I've told the judgment in exchange. So the judgment which says that the PDCs are valid, the post-dated checks and security checks are valid, is Sampede Satyanarayana Rao of 2016. And the judgment which says that if a security check was issued not for a consideration or for a future payment where the goods are defective, that is Indus Airways judgment of 2014. Now, the other defense that one can take in 139 proceedings as an accused is that the check was stolen. That is to say the check that I have was stolen and that was filled in and it was presented and it bounced. I had blank checks written with me. Somebody stole the check, presented and got it bounced. If I have given a police complaint before the time when the check was presented or before the time when the complaint was filed, if I have given a police complaint and if I have replied to the demand notice and said that the check was stolen and there is no liability, then again I have rebutted the presumption that there was a legally enforceable debt. That is a very valid ground to take in a 138 proceeding. The other ground used is forgery. What happens usually in a 138 case is that once the accused enters appearance, the signature on the check is admitted, rightly or wrongly. A lot of times this happens because the signature is not contested, it becomes admitted. Once the signature is admitted by the person that has issued the check, it becomes very difficult for a person to rebut the presumption then. If there is a slightest of the doubt that the signature may be forged, then it is always advisable that the signature is denied, that it is disputed, and once the trial begins, an application for referring the signatures for forensic examination is made. As an accused, I only have to produce the admitted signature and ask the court to examine that, send the check which has my signature for forensic examination. In the event the forensic examination comes back conclusive and says the signature seems to be forged, then again I have discharged my burden. Now the other aspect of rebuttal is if I'm able to show that the consideration itself was illegal. Now in an example, if there is a cricket match between India and Pakistan, I have bet on Dhoni hitting a century. For that bet, I've given somebody a check saying, "Savara kodtini, bet madtini. If Dhoni hits a century, you give me 1 lakh." Now he gives me a check for 1 lakh and that check bounces. The entire consideration itself is illegal. Betting is illegal. So I could not have legally or illegally given him the check for, he could have given me the check for 1 lakh. So in such cases as well, if the transaction itself is marred by illegality, then again the check does not become a valid enforceable instrument and the presumption that the check was issued for a consideration is rebutted right there. Now, the other defense that is available is of death of the signatory of the check. Now, this is also a slightly dicey area in the law because a check is a bill of instrument. So basically, by virtue of being a bill of instrument, what it means is that it is an arrangement or a contract between two persons, where I say that if this person who's holding the check comes to you, you give him the money that is mentioned in that check. Now, if as a drawer of the check, if I am dead before the check is given, then my instruction to my banker dies with me. There is no obligation or a contract between me and my banker to say that you have to honor this check. To give an example, if I'm a proprietorship concern, I'm the sole proprietor of the company and I've issued a check. And before the check is deposited and is encashed, I die. Then again, I cannot be held liable on two counts because also of 257 of the CRPC, where the death of the complainant, sorry, the death of the accused, what it does is it renders the check not a valid instrument. To give another example, say there is a joint account, me and my wife hold a joint account. I have issued a check, I'm the signatory of the check, but before the check is encashed, it is presented for encashment, I die. So what happens is by virtue of my death, my contract or my instructions to my bank also dies with me because the joint account necessarily will have to have two people operating the account. So by virtue of my death, the check no longer becomes a valid bill of exchange. It is no longer a valid instrument under the Negotiable Instrument Act. It is a piece of paper which has no value. So therefore, in specific cases, the death of the drawer of the check can also be used as a defense to rebut the presumption under section 139. Now that once a person has rebutted the presumption under 139, as I have mentioned, the burden of proof now shifts back on the complainant. Now this is where, as a complainant advocate, I will need to be very cautious. So when I'm filing the complaint, when I'm issuing the notice itself, as a complainant, I will always have to mention what the underlying transaction was, what is the particulars of the document which I have in support of this, and what is the amount. And when I'm filing the complaint, I will have to demonstrate what the transaction exactly was, what is the supporting document I have to prove that in fact this was a transaction. If there are communications where the other person is admitted to this, then that also fortifies my contention. And I will also have to specifically mention when the check was given. The check was in fact given for discharge of a liability and it was bounced. Because considering a scenario where there is a check, it has bounced, I find a complaint simply saying check ittu present madade bounce aitu case hakidini. The accused comes on record and he is able to establish that he has rebutted the presumption under 139. He is given a defense. Now the burden shifts back on my head, and as a complainant, if I have to now lead further evidence, as an accused counsel, I will always say whatever document the complainant is filing now is created, it is not genuine, and it is only to serve his purpose right now. It always creates a doubt in the mind of the judge, because even though the burden of proof is, as I said, it's a sword that hangs on the complainant's head and on the accused head, and it swings like a pendulum. First it will be on the accused head, then it will come back to the complainant's head, and in the middle, if it stops in the judge's head, and if the judge were to see that there is some loophole in the complainant's case, then the benefit will always have to be given to the accused, because probability, the preponderance of probability is the rule. If the judge sees that there is some looseness in the case of the complainant, that will result in an order of acquittal. Therefore, as a complainant counsel, it is always good that everything, every document and every contention that can be raised is raised while filing the complaint. Now, once the rebuttal of presumption or the proof of beyond all reasonable doubt, the court will pass an order of either conviction or acquittal. And about this time, and then the appeal provisions become this. This is an overview of how dishonor of check is considered under section 138. Now, the other provision that we also have to be mindful of is section 143A of Negotiable Instrument Act, which has been enacted by the amendment of 2018. Now, what used to happen is to give a statistics, there are 40 lakh check bounce cases pending in the country today. And there are 80 lakh advocates, to give a broad figure, there are 80 lakh advocates fighting tooth and nail to defend their client. Now, what happens when a check bounce case is filed? Even though the statute says 6 months is the period of time within which the case has to be disposed of, it is not the reality. And practically also, it is very difficult for a 6-month disposal. So the complainant who has suffered loss and filed the case will have to wait a good year or 2 years before he sees any money. Therefore, the legislature said that, okay, fine, what we will do is we will give a provision for interim compensation. What is interim compensation? Section 143 says that once the complaint is filed and the accused comes on record, the complainant can seek the court, and the court may, the operative word here is may, that the court may order the accused to deposit an interim compensation of maximum of 20%. So the court can direct the accused to pay 20% of the check amount, and as a complainant, I can ask the court to permission to withdraw that amount. Now, once the amount is withdrawn, consider that the case results in an acquittal. Then the legislature has not lost the sight of the accused, right? The law has said that if it results in an acquittal, then the complainant will have to pay the deposited amount that is withdrawn along with interest at the prevalent bank rate interest as per the RBI circulars. So now, due to Togondo, I cannot spend the money and have no repercussions. If it is an acquittal, I will have to repay that money. Now, the other question that arises is, will 143A be applicable to pending cases? This was examined by the Supreme Court in the case of G.J. Raja. It's a 2019 decision where the courts have held that the provision for payment of interim compensation is a procedural one and it can only operate prospectively. That is to say, 143A was added by the Amendment Act of 28 of 2018 and it was with effect from 1st of September 2018. So only in cases where the act of dishonor of checks have occurred after the 1st of September 2018, only in those cases can I ask for interim compensation. Now the question also arises is, once an order of conviction is passed, if at all it is passed, the accused will then go on an appeal. And in the appeal, the person will ask for suspension of the sentence. There also the person cannot be permitted to let go scot-free. That's why section 148 in fact was enacted. Under 148, even though the section says the court may order the deposit of minimum of 20%, in 143 it is a maximum of 20%. In 148, the sessions courts has the power to order for minimum of 25% of the check amount to be deposited before it orders for suspension of the sentence. Here again, 148, if the appeal results in an acquittal, then the complainant will again have to pay this deposited amount with interest as per the RBI circulars. Not only that, the interim compensation, if it was paid under 143 before the magistrate court, that will also have to be returned with interest. So therefore, the interest of the complainant to an extent by and large, as well as the accused, has been covered under section 143A as well as 148. Now, the other aspect that is in discussion right now is the decision of the government to decriminalize section 138. So there are more than 11 offences which have a criminality attached to it, which the government has now taken a decision to consider whether to decriminalize it or not. One of them is section 138. In fact, the government had called for opinions, and as of 23rd of June, the last date to submit opinions are over. Now, the reason why the government is thinking of this is there are 40 lakh cases pending in court, and the criminal justice system is clogged with 138 cases. So it is the argument of people who are in favor of decriminalization is that if 138 is decriminalized, then majority of the cases from a court is taken away, and the court will have more time to deal with cases which are pertaining to offences under IPC, which are the actual offences against the society. Because 138 is a civil liability which has a criminal angle to it. It's a quasi-criminal liability. So their argument is either kya ke magistrate court na use madabo, let them deal with actual crimes and let this go to a civil court. However, the repercussion there is that all these 40 lakh cases say were to be transferred to civil court. The burden of the civil court will also magnify exponentially. That will also have to be considered. Moreover, check bounce, once a check is bounced, the person who has issued the check is afraid of one, threat of arrest, second, threat of conviction, and attachment thereof. Now, if I have given the check and I know there is no criminality attached to it, I will write a check left, right, center. At dishonor rather ugly, if somebody files a civil court, if I have to pay an EMI or if I have to pay back my credit card bills, I will issue a check, let it get dishonored. What will happen? I will face a civil trial, I have no problem. That becomes a problem because the sanctity of a criminal trial with respect to a section 138 and the fear amongst people will go away. Moreover, when the legislature has taken a decision recently to say that, okay, fine, we will include 143 and 148, Now to turn around and say, no, we'll decriminalize 138 altogether, the intention is slightly ambiguous and it is not clear. However, we can only wait and watch and see what the government would do with respect to decriminalization of 138. Now, the other interesting aspect here is, let the government decriminalize 138 as long as we are not affected. What I will do is, I will say that he had the intention to defraud me when he issued the check, and I will file a private complaint under section 415. In fact, the illustration D to 415 is based on a dishonor of an instrument. Moreover, in the case of Sangeeta Bain of 2012, Supreme Court has said, if a person has issued a check with an intention, knowing fully well that the check would be dishonored, then an act under 415 is made out. For cheating is made out. So as a counsel, I have no issues even if it's decriminalized. Tomorrow, instead of filing a check bounce case, I will file a cheating case. But who suffers is the party. Because end of the day, I am only litigating on behalf of a client. And that will also have to be considered when this issue of decriminalization is considered. With this, I would think my time is also up. Yeah.
Thank you, Mr. Yashodhar, for an excellent presentation.
Thank you so much, sir. It was my pleasure, a privilege.
So can we now move on with the Q&A session, please?
Certainly, sir.
I think Mr. Putti Ramesh is already ready. Is it so, sir? Can we start with you?
Sir, you muted, sir.
Yeah, I'm unmuting, sir. 1 second. Sir, I have unmuted you.
Sir, namaskara, Yashodhar.
Okay, sir.
In fact, Belige note that when I saw the subject, I was wondering, this negotiable instruments contain just about half a dozen important provisions. How this person will, engage us for 1 hour, I was wondering. You really did an excellent job.
Thank you so much, sir. I'm humbled. Thank you so much.
So then, now coming to the question I wanted to pose. See, I'm a rich person. I don't mind losing a property. Suppose my car is stolen. I don't even go and lodge a complaint with the police. Okay, then after some time, police come to me to arrest me. Then I said, why? Sir, there's a sandload in your car, that's why we are arresting you. Then I realized the necessity of lodging a complaint when I lose a property. On the same analogy, suppose I lose a check. At least when it is brought to my notice that the check is in the custody of another person, is it not the necessity of that person to lodge a complaint, at least with a bank, that he has lost the complaint, instead of putting all the burden on this person to say that he has received a check and all those things? Why these unnecessary procedures are there?
So the problem is this: once the act of dishonor of check has already been committed, if I then go and file a complaint, it is very difficult for me to prove that I had in fact lost the check, because the presumption would be that I'm lying, that it was stolen. So the procedure is also, sir, necessary, because it is very easy for a person who has issued a check to tomorrow file a complaint with the bank or to the police to say it was stolen. And all genuine 138 cases where the complainant has in fact issued the check for a liability, they will also go for a toss. So the rule of prudence would say that if the check is stolen, one cannot sleep on his right and he will have to file a complaint immediately when he knows. But the difficulty, as you explained, sir, is that if I come to know only after the check is presented and the complaint is filed, then I have missed the bus. The only thing that we can say is that the person should have been more prudent, because the perception will be that that will be the mindset of the magistrate when the trial is happening, because I cannot prove that the check was in fact stolen before, because I will not have any documentary proof.
Okay, thank you.
Thank you, sir.
Thank you, sir. Now I'll be unmuting Mr. Ramesh Chandra. Sir, I have unmuted you. You may pose your question, sir.
Hello, Yashodhar.
Hello, sir.
You have indicated that the 138 cannot be filed against any other liability.
Sir.
No, it is not. Go through AR 2011.
Yes, sir.
Anil Char, Sachar versus Srinath Spinners Limited. AR 2011 SC 2751.
Yes.
Any other liability you can file it. It need not be a liability of a person who presented the check. It may be a liability of some other person, you can present the check.
But then there has to be a nexus between what the liability is.
It
What
was
I
so,
was trying to explain.
it was so happened.
Yes, sir.
In one of the cases, such a action was indicated by Justice Ravi Malimat.
Yes, sir.
He dismissed the complaint in my presence. I brought to the notice of this, it was not my matter. In some other matter, I brought to the notice of this honorable court. Subsequently, immediately he recalled it and subsequently issued notice to, on the, because of acquittal. Such a thing was happened. Now that's why, in order to appreciate the facts, now actually 138 has become, it is a marathon. I am not advising any client to file a 138 proceedings because we can have a decree within 1-2 years. But 138 proceedings draws fact because it is a 3-tier system. One is 138, he will drag on for another 10 years. Subsequently, it will go to the session judge. Session judge in an appeal, even if there is a conviction, 100%ly, it will not be disposed of nearly 2 to 3 years or 4 years, even for 10 years. And in a revision, it lies before the High Court for another 10 years. That is why, and it is a 30-year saga. That is why if a suit is filed, I would attend the client saying that you file a suit. Otherwise, it is not possible. The question of proving also stepped into a 138 proceedings. That is why actually 138 has become actually useless. That's why decriminalization is the best thing.
To be fair to the magistrates, they do really put an effort to finish these proceedings at the earliest. In fact, when we are prosecuting or defending 138, there is always a pressure day-to-day cross-examination ಮಾಡಿ ದಿನ trial ನಡೆಸಿ ಅಂತ. So in fact, sir, they are really trying to do it, but then again, pendency is a huge issue, sir. I agree with you.
Pendency, not only pendency. Just imagine, if a notice is after there is a judgment. Immediately after the accused appears, he has to file an application for cross-examination. That he need not once again go to the lead evidence. The question is, if in one cases, what happens? The accused appears, subsequently disappears, and in order to bring him to the court, it takes another 1 year, 2 year, 3 year, 4 year. The police are not cooperating, and even in Bangalore, especially in Bangalore, the police are not arresting the person who is actually jumping the bail. These are all there. That's why the decriminalization mode by because even 40 lakhs. Even what happens? Somebody who have 1 lakh, if there is a debt, he will file a case for 15 lakhs. This is what also happens because he need not pay court fee. This is actually it happens. That's why it is a decriminalization, the best one. That's why you indicated that decriminalization I can file a 420. That option is available. But the question is now in a present scenario, 138 has become actually useless provision.
Certainly, sir. Thank you.
Then 148, even 148 for viewers think 148 has become a now retrospective effect.
Yes.
In a 2 decision, which is reported in 2019-11 SCC 341, Surinder Singh Deswal versus Virendra Gandhi. 148, it has the court has indicated that it is a retrospective one. Yes, even in an appellate court, we can seek for interim compensation or a compensation to be paid to them. And even subsequently in the same Surinder Singh Goswal, 2020 once again. In 2 decisions, the Supreme Court has said the 148 is a retrospective one.
Yes.
But 143A is not a retrospective one. 148 is a retrospective one.
Yes.
Absolutely, sir. Thank you, sir, for sharing your views. Can we have the next question? Yes, we have Rangarajan, sir. Sir, I am unmuting you. Yes, sir. Please go ahead.
Good evening, Mr. Yashodhara.
Good evening, sir. Namaskara.
A very in-depth presentation of the subject.
Thank you so much, sir.
I should compliment you for your good efforts.
Thank you, sir.
Now, from my experience,
Sir.
today in commercial parlance, people have become very, very intelligent. Now, a check is simply not taken. A check is accompanied with a covering letter. The covering letter would disclose what is the nature of the transaction, how a debt and liability has come into existence. In discharge of that debt and liability, such and such a check is being issued, that it would be honored on the date of presentation, and if it is dishonored, you are free to proceed against me under 138. If such steps are taken, I feel the defense is almost destroyed and annihilated. Anyway, that is my view. Besides, I have two very important questions.
Sir, please.
One question is, suppose if a criminal case, upon contest, 138 case, upon context, it ends in an acquittal, whether the civil remedy is destroyed.
No,
Number
sir.
two, or is it open for the accused to say there was a full dressed trial and it has ended in acquittal? Of course, the decision of the criminal court is not binding on the civil court, and the evidence in the criminal court cannot be used as an admissible evidence in the civil case. Okay. The next question is, suppose a complaint is instituted and it is pending. And in the meanwhile, considering the lapse of time, to save the limitation, is the complainant prevented from also filing a civil suit for recovery of money?
So the answer to both questions is no, sir. In fact, there is a decision of the Daya Sapra, Vishnudat versus Daya Sapra, where the Supreme Court has in fact said that I can pursue a remedy under 138, sir, is a criminal action. I am not filing 138 for recovery of money. The court has the power to either give me the penalty or not. If the court is only passes an order of imprisonment, nothing bars me from filing a suit for recovery independently on the basis of that check.
And they can proceed parallelly also.
Yes, they can proceed parallelly. In fact, in the Vishnudat versus Daya Sapra, both were proceeded, they were instituted together and proceeded parallelly. The court said there is nothing wrong with that, because what 138 does is it's a remedy for the criminality that has occurred.
Correct. Punishment of wrong.
Yes, exactly. So both the answers is that it can happen together, and the complainant is not barred by filing a civil suit.
Thank you. Very kind of you.
Thank you so much, sir. Very kind. Thank you.
Thank you.
Thank you, sir. Now we have Gupta sir who has raised his hand. Yes, sir. I've unmuted you. Next we have Mr. Mallikarjun who has a question.
Mr. Hegde,
Sir,
how are you?
I'm
How
good,
are
sir.
you? Wonderful.
Sir, sorry to interrupt you, but we are not able to see you. Your video is off, perhaps. Could switch on the video and then proceed.
Okay.
Yes, sir.
Now I can
we
see you.
proceed with you.
Thank you, Trivikram.
Thank you, sir.
I fully agree with Mr. Ramesh Chandra that we have to decriminalize Section 138 proceedings. Now, coming to my question to Mr. Yashodhar Hegde, the complainant is a private limited company, and the person who has issued the check had some transaction, some trading of shares, and checks are issued for the outstanding amount to the company. See, in the meantime, what happened to get the advantage in the income tax department? They have written off the debt. Now they have filed a complaint. Now, is it the complaints are maintainable?
Sir, it would be
The
maintainable.
acknowledgement of liability is there, checks are issued, all procedures there, but there is a difficulty here.
Sir, if the debt is written off before the check was bounced,
Yes,
that is to say, because as of today, I need not have to, by the books, I may not owe them anything. But there is a liability that arises on me because for the share transaction, I was supposed to pay them the money, they were supposed to receive it from me. So the debt is a legal debt. them writing it off or otherwise will not have too much of a bearing with respect to my offense of dishonor of the check.
Okay.
Then again, sir, it is also dicey. What I can do as an accused is I can say that in the reply notice, if I state that the debt is extinguished, then, sir, I have a valid defense to say that the check is not, it is not a dishonor of check offense. That means the timeline of when the debt was written becomes very important in these matters.
Okay.
The time of commission of the offense, if the debt is still existing, then I am still be liable for a prosecution under 138.
But again, it's a gray area.
It's a gray area, sir. Yes.
Okay. Thank you.
Thank you so much, sir.
Okay.
Sir, all civil practitioners say that it has to be decriminalized, and all criminal practitioners say that it should not be. So, anyways, Mr. Mallikarjun, I have unmuted you.
Thank you.
Yes, you may go ahead with your question.
Good evening, Hegde sir.
Good evening, sir. Namaskara.
Very good and very articulated presentations.
Thank you so much, sir.
So I have a question, sir. In Anita Ada versus Godfather Travels reported in 2012, Part 5 SEC 661.
Yes, sir.
Wherein SMS Pharmaceuticals, Anita Ada versus Indian Acrylic case have been overruled by the Honorable Full Bench of the Supreme Court.
Yes, sir.
Wherein it was clearly held that it is an irreducible conclusion that maintaining prosecution under Section 141 is a sine qua non for company should be arraigned as a party, without which complaint shall not be maintainable, only impeding director of the company, against the director alone.
Yes.
Suppose, my question is, suppose if the complaint is being filed, cognizance is taken, and somehow the case is progressed, then whether that defect can be curable, can we amend the complaint under Section 138?
The problem is CRPC 1 does not give me the power to amend. So 6 Rule 17 or 151 is not, the parameter provisions to that is not there in CRPC number 1. And number 2 is for what constitutes my basis for a prosecution is the legal notice. If the legal notice is not issued to the company, I cannot go back in time and rectify the defect. That defect is not curable, sir. In fact, that is what is also has been held in the full bench decision of Anita Hada.
Hello.
If the complaint is not proceeded against, the company is not proceeded against, then the case will have to fall because there is no legs for the case to stand on. Hello?
But sir, my doubt is another Supreme Court decision wherein there is no need to issue to the company as well. All the directors notice issuance of the director is as well as suffice to issue the company itself.
Sir,
So
that is on a different aspect. In fact, there are two decisions here. One is a 2014 decision where the courts have held that if you have issued the notice to the company, then the directors are deemed to have been aware of it. However, sir, the second proposition what you said, there is a divergent opinion of the court. If I have issued the notice to the director, that does not mean that he would inform the company. So the onus is on the complainant to make sure it is issued to the notice is issued to the company. That, sir, is only restricted to issuance of the notice. That is, if I have given it to company, will it suffice to say that the directors would be aware? And if I given it only to the directors, can I say that the company will also be aware? That is where the court has drawn a distinction. But for prosecuting for an offense, if I have no grievance against the company which has issued the check, I cannot possibly have a grievance against the directors. So those two, the distinction I'm trying to draw here is, if the notice is issued to the company, the courts have held the directors are deemed to be aware of such a notice. You can proceed against the directors also in the complaint. When it
however, sir, in the latest Madhya Pradesh High Court reported in 2018, wherein it is a curable defect and it can be amended under Section 190 of the CRPC. There is a Madras High Court judgment in Manish Kalal versus another versus Housing and Urban Corporation Limited.
Even in Manish Kalal and this, the Supreme Court has also time and again held that the inherent power of a magistrate court is only to cure defects which are otherwise of a smaller nature, like if there is a mistake in the numbers or something. Now, for me to say that I can amend the complaint and go back in time, so there is no definitive ruling by the Supreme Court on this aspect to say you can amend the complaint and include the company as a separate accused.
If that defect is there, can we withdraw the complaint, save limitation, and go for a civil case?
Sir, civil case I always have a remedy regardless if I have.
No, whatever. By the time already 3 years is last probably, but the complaint.
Sir, no, I cannot take refuge under Section 14 of the Limitation Act to say this I have prosecuted with good faith, because there are two separate remedies. Criminal remedy and civil remedy, I cannot mix them and say I need to avail the benefit of litigation. That I will not have.
Okay.
That will not come to my rescue.
Okay, sir. Thank you. Thank you very much.
Thank you, sir.
Very good.
Thank you, sir. Now I am unmuting Mr. Nitin. That would be our last question. Yes, Mr. Nitin, I have
Harish also had a
allowed you to talk.
Hello, can you hear me?
Yeah, I can hear you, Nitin. Hi.
Yeah, thank you very much. It was a very wonderful lecture. I really liked it. I'm from Mumbai. I got 3-4 questions for you, sir.
Yes, sir.
Number one,
You will have to keep it
I
very short, and
absolutely-
I'm sorry to interrupt you. You will have to keep it short and quick.
yeah, short only. Only these were in relation to the earlier questions. I'm very sorry. My first question was, sir, let us assume a situation. I issued a check, and then immediately I file a NC and say that my check has been stolen. I gave it to you because there was there was a debt. In discharge of that, I gave you, and immediately I filed. So, what is the remedy available for you, sir?
No, can you repeat? You have issued a cover
I have
letter
given
saying
you
there
a
is
check, okay,
Mhm.
and I'm so I'm a bad person. I don't want to give you the money. So immediately I went to the police station and say that my check has stolen, okay, and then I file this thing, and the check get bounced. You send me a notice.
Yeah, so the
Then in
remedy
that
there is
notice I complain.
if you have in fact given me the check, I'm sure there will be some transaction that I will have. So as a complainant, I will need to prove that the complaint that you've given is wrong and that there was an underlying transaction, which is what is the truth. So then again, it's a matter of trial. So there is no straitjacket formula to say that no, just because you've issued the complaint before the check was bounced, that doesn't mean that that has to be taken primacy over every other fact.
Okay. And my second one was, sir, now let us assume a situation you have said about it's a criminal complaint. Rangarajan sir had also asked the similar line question.
Yes.
My question was, let us assume that fine has been imposed double the amount of the check. Now that fine has been given to me as a compensation.
Yes.
Okay. Now can I go to a civil court for getting my principal amount, and will this amount be considered by the civil court? Okay, I have got that particular as a
Yes. See,
compensation.
what happens is once the penalty is levied and the amount is cleared, then the check is a discharge instrument. So I don't need to discharge the check anymore.
Okay.
So
okay.
the liability
So,
under the check stands discharged. So I cannot then maintain a civil remedy as well.
okay. So you meant to say that I got the money, the question is over, I can't go to the civil court.
Yeah,
And
because
sir,
if you go to civil court, you have to say that the check had bounced and that was a liability. Correct? So the criminal court has already extinguished that liability by paying you the compensation amount in lieu of the check amount.
And sir, there were defects in my criminal complaint. Just to bury that defects, I knew that he got acquitted. Now, can I put a burial upon those defects which were there I couldn't fulfill by virtue of filing a fresh civil suit? Can I fill up the lacuna which were present
the
there?
lacunae in a criminal case and that of a civil case are two different aspects. In a criminal case, as a complainant, I will need to establish that the ingredients under 138 were met. In a civil case for a check bounce, I need to show that there was a check, there is a transaction, and there is a liability which he needs to pay me. So we have to understand 138. I am saying that the offense is what I want to prosecute, that he has wronged me. In a civil liability, I am saying the money has to come to me. So the defect in criminal complaint need not be the same defect in civil complaint, in the civil suit. That's what I'm trying to say.
Thank you, sir. Sir, you're a very nice teacher. You have really explained us so well. I'm very thankful to you.
I'm grateful.
Thank you very
Thank you
much.
so much. Very kind of you. Thank you.
All right, Mr. Yashodhar, thank you. Before we wind up today's session, Mr. Sharat Chandra has an offline question. When court passes an order for payment of interim compensation, and if the accused does not pay it, what is the consequence? How
So the
can the
consequence,
complainant enforce it?
yes. So 143, the judgment which I mentioned earlier of 2019 states that 60 days is the time limit for the accused to pay the money, and 30 days can be extended by a further period of 30 days. If in 90 days the accused does not pay the money, then section 471 of CRPC will have to be inserted. It has to be adhered to, and that money can be recovered as land revenue or by attachment of movable and immovable properties of the accused. So the enforcement of that is also taken care by 143.
So could you throw some light in view of the present pandemic? Say there was an order passed in the month of Feb, and the time has elapsed by end of say 60 days would
So
have
now
elapsed
we have
somewhere
to
in
take
April.
refuge under suo motu 3 of 2020 of Justice Nariman's order, where all the limitation which provided by statute or otherwise stands extended. So the only option available is to take refuge under that order and say that since the courts are not regularized, the limitation period stands section 8 sine die until otherwise ordered by the court. So on that aspect, I can say that the 90 days has never elapsed and it is still running because by operation of law, because the Supreme Court has invoked section 142, the plenary powers of the court, to meet the ends of justice. So on that, the only refuge I have is to say that the limitation is not yet over. 90 days is still running because the court has given me that power.
All right, thank you. So one last question by Mr. Harish, and we'll be winding up the session. Sir, very quickly, you may pose one question. I've unmuted you.
Congrats, Hegde, for an eloquent presentation.
Thank you so much.
You mentioned that in a check issued under a joint account, the joint account holders cannot be prosecuted if only one of them has signed the check. Okay?
No, sir. What I said was if one other account holder dies.
Pardon?
The joint account holder example I gave, when the other account holder dies before the check is presented, death of the signatory.
So it's not not when one person has signed the check.
No, sir. If one person is signed as a joint account holder, I again will have the liability.
Will be liable. That's why.
Yes, sir. Yes.
Sorry, I heard it wrong.
No problem. Please. Thank you so much.
Thanks, sir. Mr. Yashodhar, on behalf of Advocates Association Bengaluru, I extend my heartfelt thanks to you for a stupendous and brilliant presentation. Thank you so much.
Very kind.
With this, we'll be logging off today's session.